You built your business from nothing. Long nights, years of stress, missed vacations, financial risk. And now that divorce is approaching, one thought keeps running through your mind. What if I sell the business before the divorce, so my spouse can't touch it? At first, it sounds smart. Sell it, transfer ownership, move the money somewhere else. Problem solved, right? Not exactly. Because under Florida law, trying to sell your business before divorce to protect it can actually make your situation much worse. For many business owners, the business isn't just an asset. It's your identity, your livelihood, your future income. So naturally, when divorce enters the picture, panic sets in. People start looking for ways to protect what they built. But here's the reality. Selling your business before divorce usually does not eliminate your spouse's claim to the value. It simply changes the form of the asset. Instead of business equity, you now have cash proceeds, which may still be considered marital property. And if the court believes you sold the business to avoid equitable distribution, the consequences can be severe. How Florida law views the business. In Florida, if the business was built or significantly grew during the marriage, it's often considered marital property. That means the court can divide the value of the business during divorce, even if only your name is on the company, you started the business yourself, or your spouse never worked there. Because courts look beyond ownership paperwork. They look at whether marital effort, marital funds, or marital support helped build the business. And if they did, your spouse may have a claim to part of the value. So what happens if you sell it? This is where many people misunderstand the law. Selling the business does not magically erase the asset. The proceeds from the sale can still be traced. During divorce, attorneys can subpoena bank records, tax returns, and financial statements. They can also subpoena wire transfers, business records, and asset purchases, which means the court can follow exactly where the money went. If you sold the business and hid the proceeds, gave money to family members, moved assets offshore, transferred funds into secret accounts, or spent the money recklessly, the judge may view it as intentional dissipation of marital assets. And Florida courts take that very seriously. Dissipation of assets. Florida law specifically addresses situations where one spouse intentionally wastes, hides, or depletes marital assets before divorce. This includes actions taken after filing or even within 2 years before filing for divorce. So if the court believes the business sale was designed to unfairly reduce what your spouse receives, the judge can award your spouse a larger share of other marital assets. The judge can also credit your spouse for the missing value, order reimbursement, or severely damage your credibility in court. And credibility matters enormously in divorce litigation. Once a judge believes someone is hiding assets, every other issue becomes harder. Red flags that courts look for. Judges pay very close attention to business sales that happen near divorce, especially when certain red flags appear. For example, selling the business to a family member, or selling below market value, transferring ownership into trusts or LLCs you still control, or continuing to secretly run the business after the sale. Deferred payment agreements that don't make business sense, or selling right after major marital problems begin. If you sell a $2 million company to your brother for $400,000 and still keep operating it behind the scenes, the court is likely going to see right through that. Even legitimate sales can face scrutiny if the timing looks suspicious. How businesses are valued. A lot of people also assume, my business isn't worth much. But courts use business valuation experts to determine fair market value. They examine revenue, profitability, assets, and future earning potential. They also look at customer lists, brand value, goodwill, and industry comparisons. And in Florida, something called enterprise goodwill may also be considered marital property. That includes value tied to reputation and systems. It also includes brand recognition and customer loyalty. So even if the business itself isn't sold, the value still matters during divorce. Smarter legal strategies. Instead of trying to secretly sell the business, there are legitimate legal strategies that often work much better. For example, negotiating a buyout of your spouse's share or offsetting the business value with other marital assets. Structuring installment payments over time or getting a professional valuation early. And keeping strong separation between business and personal finances. These strategies protect your credibility while helping preserve ownership. Because the goal shouldn't be hiding assets. The goal should be protecting the business legally and strategically. Contact Nest Law today.